You know what's a really silly argument? When someone says in a political debate, "I've read the Charter, have you?" Like it's a mic drop. So I first noticed this in American debates when people would proudly declare that they've read the Constitution, and I always thought it was absurd. I found it puzzling why anybody would take that seriously. And I heard that for the first time in the Canadian context during the trucker convoy. It was during a live call-in debate between supporters of the convoy and opponents of it, and one person said they'd read the Charter, and the other person shot back, "So have I," as if that was supposed to mean something. But I don't know what the argument actually means. Like if somebody told me in a debate, "I've read the Charter," I would have no idea what they meant by that. Like, here's why I find it puzzling. Saying you read the Charter, it's a bit like saying you've read the periodic table of elements so you understand chemistry. I've seen the periodic table of elements. I could probably even recite some of the symbols, but I don't know the first thing about chemistry. Like, what's a covalent bond? Or why does it matter? I have no clue. So in the same way, just saying that you know Section 2 of the Charter protects freedom of expression doesn't mean you actually understand how that freedom works in law. To know that, you'll have to look at the tradition of case law. In other words, how the courts have interpreted and applied those words over decades. So let me give you another analogy for thought, just to keep in mind what the practice of law is. Imagine that a famous pianist said, "To be a good pianist, you need to practice a lot." That advice sounds obvious to everyone, but the problem is with what concretely they mean. What does a lot mean? Is it, 30 minutes 3 times a week for a month? Or is it more like, 5 hours every day for 20 years? There's an awful lot of room for interpretation there. Frankly, it's not even clear what they mean by practice in that example. Like, does any time at the piano count as practice? Does it have to be scales and arpeggios, specific pieces? That's exactly how the law works. A document like the Charter will use words, for example, freedom of expression or peaceful assembly, but those words only gain real meaning through the courts. I think sometimes people confuse law and philosophy. So in philosophy, you can take any argument you want and defend it. It doesn't matter if the argument is counterintuitive or unusual. In fact, that may even be to its credit. You could doubt the existence of your physical body, if you like, and doing so might even earn you a spot amongst the greats of the canon. But in law, you're bound by case law, which is essentially that tradition that courts have within themselves in their discourse, or a little ongoing conversation about the issue. Yeah, you can always try to distinguish your case from previous cases, but that's not the same as saying that you can just make up any interpretation out of thin air. That's usually not possible. So that's why when people say, "I've read the Charter," it's just meaningless, Most people who've never read the Charter could still guess that it protects things like freedom of expression and peaceful assembly. What matters is knowing what the courts have said about those freedoms, what the principles are that governs them, and also, to the extent possible, seeing how they've been applied in real cases. So take the example of the convoy. Yeah, of course it's true that protest is protected to some degree, like Section 2 guarantees freedom of expression and peaceful assembly. Well, yeah, that's obviously going to have a lot of common ground with what we normally mean by a protest. But that's not the end of the story, right? Courts have made actual rulings on protests in various contexts. They've defined boundaries, limits, responsibilities, those kinds of things. So before you claim that a particular protest, such as the trucker convoy in the Ottawa context, is lawful, you need to know what the courts have actually said about protests. Otherwise, saying "I've read the Charter" and then saying it's legal or it's illegal, you're just guessing. It doesn't mean anything. For the record, here's just a snippet of the things the courts have said about protests in Canada, and I stress that this is just a snippet. Let's start with the 1986 case known as Dolphin Delivery. That was a case concerning secondary picketing, and it focuses primarily on the question of whether the Charter applies to the common law. But for our purposes, what's important is that the Supreme Court in that case made it clear that while the Charter protects freedom of expression, that freedom's not absolute. It noted that some actions that accompany the expression in question would be protected, but that protection would not extend to acts or threats of violence, the destruction of property, or other, quote, clearly unlawful conduct. Consider another example, the famous Montreal case, which involved a strip joint that got into trouble with the city because it was blasting music in the street with a loudspeaker. In that case, the court recognized that noise can be expression, but it nevertheless found that limits on it were justified. So essentially, though this is not exactly the point of the case, because the case focuses a lot on location of the imputed expression, namely the public street, We might be left with the impression, after reading this case, that limits on noise are likely to be justified when the level of disturbance becomes intolerable. Consider yet another case, the Occupy Toronto case from 2011, which is an example of a case that hits directly on protest, and this case was also followed closely by some other courts shortly thereafter. So the Occupy movement had been spreading, and in this instance, the protesters who had been camping in the park were given a trespass notice preventing them from installing, erecting, or maintaining a tent, shelter, or other structure in the park, and from using, entering, or gathering in the park from 12:01 to 5:30 a.m. Ultimately, the trespass notice was upheld by the Ontario Superior Court of Justice and the protesters lost their application. Essentially, the case stands for the proposition that the Charter doesn't protect the right to occupy public space indefinitely to the exclusion of others. So yes, protest is protected, but courts have been consistent. Once your protest blocks streets, drowns out residents, or occupies space indefinitely, it stops being lawful protest and starts being unlawful harm. So the next time you hear somebody say, "I've read the Charter," remember, that's like saying you've read the periodic table of elements, so now you understand chemistry. Yeah, you might know the symbols, but it doesn't follow that you know the science. I'll end by introducing something that's bound to be a recurring theme on this channel, the descriptive-normative distinction. It's a favorite amongst philosophers, to be sure. Normative here is used in the way it's typically used in philosophy, so that means what ought to be, right? Questions about what one should do. So it's prescriptive in that way. So the descriptive-normative distinction really is about, on the one hand, descriptions, what is, and prescriptions, what ought to be or what we ought to do in some situation. So when people say, "I've read the Charter," and then they proceed to take a position on, for example, whether a protest is legal or illegal, they're likely confusing the descriptive and normative domains. They're not really describing what the law says, despite purporting to do so. What they're really doing is telling us what they think the law ought to say.